Case number 113493, State of Kansas v. Lorenzo Pulliam.
May it please the Court, Corinne Gunning from the Appellate Defender Office, appearing on behalf of Lorenzo Pulliam. Mr. Chief Justice, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Brief factual background. Following a shooting on August 22nd, 2012, caused injury to Zach Eisdorfer, and killed Zach Burton, the state charged Lorenzo Pulliam with attempted first-degree murder of Mr. Eisdorfer and second-degree murder of Mr. Burton, in addition to criminal possession of a firearm. A jury ultimately convicted Mr. Pulliam of attempted voluntary manslaughter of Eisdorfer and second-degree murder of Burton, as well as the criminal possession of a firearm. On appeal, Mr. Pulliam raised 4 trial issues and a single sentencing issue, all of which were affirmed by the Court of Appeals and petitioned to this court. This court granted review on a single issue, the second issue in the petition, whether the district court erred in failing to instruct on the lesser included offense of involuntary manslaughter, the imperfect self-defense version of that, of Mr. Burton. And per that order, I will simply be arguing that second issue, that the district court should have instructed on involuntary manslaughter. The Court of Appeals, based on the 4 factors that we look at when we're looking at instructional issues, the Court of Appeals found that they did have jurisdiction and that the instruction was legally appropriate. What they found, however, was that the instruction was not factually appropriate. And for determining factual appropriateness, it's whether there was sufficient evidence viewed in a light most favorable to Mr. Pulliam in this case that supported giving the instruction. My disagreement with the Court of Appeals' opinion is that it was grounded almost entirely in a case, State v. Houston, that was decided in 2009. And State v. Houston was very similar facts to this case, as argued by the state in this case. However, this court in Houston relied on a reading of the statute that just is not the same any longer. Involuntary manslaughter at the time that Houston was decided was listed as unintentionally killing a human being under various different circumstances. At the time, in 2010-2011, when the legislature recodified the criminal code, they removed the language of unintentional killing. And from my perspective, that's the entire basis of the opinion in State v. Houston, is the existence of that requirement that the killing be unintentional. And so, from my perspective, case law relying on the inclusion of that word unintentional has little to no relevance any longer to this question because of the recodification.
What does have relevance at this point? Where does that get us? The statute's changed. Where does that get you?
I think that we just simply look at, obviously, without unintentional, we're not looking at whether or not this is an unintentional killing. What we're looking at only is whether or not there was a killing of a human being committed as a lawful act in unlawful circumstances. And so the question is, the lawful act, whether Mr. Pulliam lawfully acted in self-defense, but he used excessive force when he did so. And in this case, the district court instructed on second-degree murder and voluntary manslaughter in perfect self-defense as a proper lesser, as well as instructing on the affirmative self-defense, the perfect self-defense. So the district court already found that there was enough evidence presented to the court to support that lawful act. So then, from my perspective, that the only question is whether or not Mr. Pulliam if there's evidence that Mr. Pulliam used excessive force when he shot Mr. Burton. And I think that the evidence is clear. Mr. Burton was unarmed, and Mr. Pulliam used a gun. So it's from my perspective, almost bringing a gun to a fist fight. That's excessive force. And so he did have,
There was evidence that the other person who was injured had a gun, though.
yes,
Okay.
yes, and that Mr. Pulliam knew he had a gun. Mr. Pulliam was unaware whether or not Mr. Burton was armed or not. Mr. Burton wasn't wearing a shirt, so it was a little more obvious. But he, in seeing him coming towards him, in seeing Mr. Burton coming towards him, he felt under attack, and so he simply shot him. And so, from my perspective, I think that Houston is no longer good law because of the change in the statute, and that the evidence does support, first, that there was a lawful act here, as the district court already found that there was evidence to support, and that there was evidence of excessive use of force.
Go ahead and jump us to clear error.
Yes, and that was not reached by the Court of Appeals, so it's not included in my petition for review. But I do think that this court can reach that in the interest of judicial economy. In this case, as I already said, the court gave the affirmative self-defense instruction and it gave the voluntary manslaughter instruction. Both of those instructions require a finding that Mr. Pulliam either reasonably and honestly believed that he was justified in the use of deadly force, or unreasonably and honestly believed he was justified in the use of deadly force. If the jury were to say, well, we think that he had a reasonable and honest belief, but not to use deadly force, there was no other option for them to reach in this case, except for the second-degree murder, because the level of force he used could have been a deciding factor here. I mean, the jury did convict him of the lesser, going down all the way to voluntary manslaughter of Mr. Burton, Mr. Eisdorfer. So if the jury said, well, we just don't like the fact that Mr. Burton was unarmed and he shot him with a gun, but we don't have an instruction there for him, that this case could be decided on that excessive force. The jury...
That's not the standard. You've got to firmly convince, you've got to convince us that that's
Yes.
the outcome. So that's what I'm trying to get at, because this jury convicted of second-degree murder.
Correct.
And I'm just trying to see, make your, convince me that the outcome would have been different.
And I suppose I thought that's what I was doing, but...
No, what you told me was that they could have done this. They could have done, they could have done a lot of things if they'd have been given different permeations of the question. But where does this evidence take us in terms of making those conclusions?
Well, the evidence shows that, Mr. Pulliam, the evidence shows that Mr. Pulliam did have a belief in the need to use deadly force, and that he simply used the wrong level of force. And so I think that's there's no other option available to the jury to find that. I don't know, the evidence simply shows that he shot an unarmed man, which is, I think, a jury is not going to acquit someone of that when that's what the evidence shows. And so the only option available to them was the second-degree murder. So if they had the option of considering involuntary manslaughter, the evidence shows that he did have a reasonable belief that he was under attack, an honest and reasonable belief that he was under attack, given the circumstances and his knowledge and experience, but that he simply responded with the wrong level of force.
Why didn't self-defense cover that scenario here?
Because self-defense requires a reasonable and honest belief that you are justified in using deadly force. And if the jury found that he was not justified in using deadly force, they couldn't find, if they found that he was justified in using non-deadly force, they couldn't find that he was justified under the perfect self-defense. That's what would be encompassed by the imperfect self-defense of involuntary manslaughter.
Was he instructed on the imperfect self-defense? I thought he was.
Only under voluntary,
only under voluntary
not
manslaughter.
involuntary.
Okay.
Which both of those,
Let me just
Yes.
let me just back you up and
Yes.
have you repeat that so I make sure I understood what you said. Self-defense covers deadly force, but not the situation where he was okay to use force, just non-deadly force. And you're saying the evidence could have supported that conclusion, and that's why it's vital to have involuntary
correct.
and not just self-defense and voluntary.
Correct.
Okay.
And a similar principle is for the voluntary manslaughter, imperfect self-defense. There has to be an honest belief that you could use deadly force.
Right.
And so I believe, well, based on the evidence that was given to the jury, they were not able to reach a verdict if they found he was able to use force but not deadly force. They were stuck between the decision of convicting of second-degree murder or acquitting. And in that case, they chose second-degree murder because he admitted to shooting Mr. Burton. It's the mitigating circumstances that were not presented to the jury of using excessive force that the jury should have been presented with and given the opportunity, and I believe that they would have considered that. And I think that the outcome would have been different.
And how does the outcome on the attempted first-degree murder support you? You tried to explain that earlier, and I think maybe we didn't let you completely finish, but I didn't quite follow that argument. You said the jury went to a lesser on that.
Yes. Mr. Eisdorfer was shot, and Mr. Pulliam knew he was armed.
And he was shot first.
He was shot first, and the state charged with attempted first-degree murder. The jury was instructed on attempted first-degree murder, attempted second-degree murder, and attempted voluntary manslaughter, the imperfect self-defense. Mm-hmm. And the jury convicted him of attempted voluntary manslaughter based on an unreasonable but honest belief in the need to use deadly force. So the difference between those two individuals, Mr. Burton was not armed. Mr. Eisdorfer was. And so the difference is that you could reasonably believe and honestly believe that you had the need to respond with deadly force to someone who has access to the gun and you know that they have a gun, whereas it's more likely that it is excessive force when you shoot someone that is unarmed. So the jury did go down to, they found those mitigating circumstances in Mr. Eisdorfer's case, but the mitigating circumstances they were presented with for Mr. Burton would not have fit the evidence because it's reasonable to believe that if you shoot someone who is unarmed, that's excessive and not a justified use of deadly force.
Okay. And the evidence was that he was some distance from Eisdorfer, but basically point blank with Burton?
Yes, it's a fairly small room. I don't think that he was super far away from Eisdorfer, but it's within a couple of feet from the time that Mr. Burton moved toward him and he turned and shot him.
Eisdorfer wasn't moving toward him.
No, Eisdorfer was sitting in his chair.
Okay.
If there are no further questions, I'll conclude my initial presentation.
Any more questions? Thank you, counsel.
Good afternoon, almost. May it please the court. The state appears by Jennifer Tatum, Assistant District Attorney, Wyandotte County, Kansas. The state's position in this case is, number one, that the involuntary manslaughter instruction was not factually appropriate. And number two, even if you find it was, that this case should not be reversed because it would not have mattered had the jury been instructed on that. There would have been no different result. We're asking that you uphold the Court of Appeals opinion as well as the district court's decision not to give such an instruction. Even the defense attorney at trial in this case thought that involuntary manslaughter instruction would be a stretch.
That's the quote.
His word.
But the
right.
context is recklessness.
I'm sorry.
The context is reckless involuntary manslaughter. The context of the stretch comment is reckless. I think the judge had talked about including the instruction, just
Sure.
maybe it was in the packet that would
Right.
ordinarily be given. And then the state objected. I don't know whether you tried this case, but the state objected. And then the defense said, I think you should give them all, but that one would be a stretch. That's your quote. But that was in the context of, they were talking about reckless involuntary, not this imperfect self-defense involuntary.
Well, and perhaps that was exactly what Mr. Stone was talking about at the
Okay.
time, but I think the facts are important here, and I think the reason he thinks it's a stretch is the same. What we have here is Mr. Pulliam and Mr. Eisdorfer being friends. Mr. Pulliam often hung out at Mr. Eisdorfer's house. He knew Mr. Eisdorfer had a gun. He knew that there were drugs that were done at that house. He chose to come and go there freely, despite his condition of PTSD, despite the fact that he claims he was afraid of guns. In fact, on that very day, he was over there. He had come and gone a number of times. He saw Mr. Burton walk into the house. Now, this is not Mr. Pulliam's home. He did not have to be there. He saw him walking in. He chose then to go ahead and walk in and confront Mr. Burton for some reason inside rather than simply leave at that point. When he went inside, by all the testimony, including the surviving witness, Mr. Eisdorfer, as well as a woman who was there that Mr. Pulliam was romantically involved with, it was a very, very quick exchange between him walking in and shots being fired.
Yeah, she said 30 seconds. didn't she?
Burton was hit first, actually. That's the way that I understand the evidence. He's hit first. He's hit at point blank range through an eye within 2 to 3 feet. And after that, a gun battle ensues throughout the house with Eisdorfer. Eisdorfer is eventually shot twice, but by Eisdorfer's testimony, he didn't even go for the gun until this shooting happened, which actually makes sense in the context of the facts. Then we have the defendant fleeing the scene. So the defendant initially, when he is arrested, tries to say, and I think that it's really important to consider all of these facts because the jurors did. This is what was in front of them. And initially the defendant says some unknown woman did the shooting. So he starts with that. He then, when he initially speaks to police, tells them, I went in there. I do suffer from a condition. I get jumpy. I heard a noise. But I did not believe either Burton or Eisdorfer were any sort of threat. I did not see any weapons. I think he said he heard someone say checkmate, but what that means, I can't tell you. I would say it certainly doesn't justify pulling out a weapon and shooting someone through the eye quickly like that.
Didn't he testify? Wasn't there testimony that he thought he heard a gun cocking?
That came at trial. So his testimony had evolved by the time of trial, and at trial it became more of a self-defense issue. So at trial he mentioned he heard that. But again, in the context of everything that happened with the surviving witnesses, one of whom was dating him, so you would assume she might have a bias towards him, not against him, said this all happened extremely quickly. And he actually follows Burton in. So I think the jurors these were the facts that we had. And under these facts and circumstances, there's just no way to conclude, or there's no evidence that this was a lawful act done.
Why was self-defense given then?
I think self-defense was given so that they can consider whether or not he had the objective belief.
Reasonable and honest belief.
Subjective belief, correct?
Yeah,
And
objective, subjective prongs.
Right.
So if the jury should be permitted to consider that,
Right.
why not the still lesser lawful act of self-defense unlawfully committed
Because
by excessive force?
I think in general, and that's why voluntary manslaughter was given, self-defense is an intentional act. If you're defending yourself and you make the choice to do that, it's an intentional act. Involuntary manslaughter, and I understand they took out the reckless when they changed the statute,
They didn't take out reckless.
Right,
They
but-
took out unintentional.
Sorry, thank you.
I mean, it's really very confusing what the committee recommended and what the legislature ended up doing on the homicide statutes and on the culpability.
Right. And I
statute.
can't say I'm extremely pleased with it, but it is still involuntary manslaughter as opposed to voluntary in the
So
nature
you,
that
but
word.
you really kind of have to rely upon the label of the statute in order to say that it still has to be an unintentional crime, don't you?
Yeah, yes, you can, yes, you do with regards to this particular thing. But
And
I
this
think,
is the particular one we're talking about.
right,
That's why
yeah.
I'm bringing it up.
But I think that's okay. I don't think there's anything wrong with that. I think, yes, the
That
statute.
was another critical component of the Court of Appeals decision, wasn't it? That they read that label and said it necessarily implies it has to be unintentional conduct. And that's why it remains mutually exclusive with intentional crimes.
Yes, and I do think that was a critical part of their opinion.
So if we disagree with that, that's a
Disagree with
problem.
what?
If we disagree with them on that they can't just rely on the implicit unintentional nature of it, something that's involuntary.
Yeah. I think if you disagree with that, then we go to clear error in this case, because I
Okay.
don't know how to fix the language of the statute at this point.
I was having trouble figuring that out too, so I'm glad
Sure.
to hear we agree on that point.
I don't know how we fix that. I would say this. I mean, I know they relied heavily on the Houston case, and I went back and looked at the years that some of these were decided. One of the cases I cited in my brief to Court of Appeals that they didn't cite, but it was argued, was a 2012 case, and that was the McCullough case. And that case involved, again, even though it was post-amendment, this court relying on the fact that this is unintentional. An involuntary crime by nature is an unintentional crime. And so I think that that could matter, even if the Court of Appeals didn't rely on it. I think the idea behind Houston is still sound. When you had a case, even though at that time unintentional was language that was used, but when you have someone who says, hey, I use self-defense, but then he gets out of the car and says, I was so tired of this, that's why I got out of the car and pulled the trigger. I mean, I think that applies here too. When you see someone's actions that are absolutely intentional, then there's not evidence that would justify giving an involuntary manslaughter instruction.
What is the crime that your opposing counsel has suggested was committed here? Where you have a reasonable and honest belief in the necessity of the use of force to defend yourself, but you carry it out excessively.
Yep.
What crime is that?
I don't know what the crime would be other than that at trial he said a gun being cocked, so maybe he...
No, I just mean in the abstract.
Yeah.
Sure, like maybe...
Like,
Mr.
is that even a crime? I mean, it sounds like you're arguing that because this instruction is not factually appropriate here, that's not a crime.
Yeah, I don't think that a crime did occur against Mr. Pulliam, if that's what you're asking. I'm sorry if I'm
No,
not...
I'm just asking, just again, very 30,000 foot level. If an individual is legally justified in the use of force, but exceeds that justification by being excessive. The use of force that was justified was simply, it was something short of deadly force, but the person uses deadly force. Is that a crime?
Yes,
And what crime is it?
involuntary manslaughter.
Okay.
I'm
That's-
sorry.
That's your,
I think
that's your
I'm not
opposing counsel's
I
argument.
think I'm not as bright as you. I'm sorry. I'm not.
No, I may not be
following
phrasing the question right, but I understand that to be defense counsel's argument. That that's the crime that the jury should have been permitted to consider because because it fits the facts here.
Okay, I understand. I thought you were asking me what crimes or what reason he would even have to defend himself against the victims.
Burton,
And if that's the crime, why isn't it factually appropriate here? I think what you said to me a few minutes before you got asked the question by Justice Siegel was if we say that's what happened here, then it was factually appropriate, and that's just whether we still buy the Houston, it's mutually exclusive stuff.
I think the reason it's still factually inappropriate is because by all accounts, even the defendant's own account at trial, this was intentional.
Right, but then we have to accept your label carries the day argument, and I said if we don't accept that, you said then I'm talking about clear error.
Yes, and
Yeah.
I still
You
will
have to go to harmlessness. Okay.
stand firm on that. But yes, I mean, there's no indication even from the defendant himself that he meant to do anything other than kill Mr. Burton. I mean, you shoot someone in the eye at 2 to 3 feet. There's just no indication it was an unintentional crime. But going to clear error, because I'm not sure what else I could say about the statute to convince you, I don't think anything would have changed. I don't think the result would have been different. They had the voluntary manslaughter instruction in this case. They did not choose to believe he had any sort of reason. Well, I don't know which one they found, but they did not believe that this was self-defense carried off on his honest belief.
They apparently believed something about self-defense because of the result on the first degree, his attempted first degree. I mean, they went lower on the other victim. So
Right.
how do we read that?
I think that's a little different because Burton was the first one who was shot. He was shot right away. He had no weapon. And then there was testimony that Eisdorfer did have the gun. That Pulliam knew he had the gun in advance, which I also think makes it somewhat different, and that he pulled it and fired it at him probably at least once. And that there was a chase throughout the house where bullets continued to be fired. So I think
he said on that deal on how that all went down.
Sure, but there was testimony that there was a chase and there were bullet fragments in other rooms, so we know some shooting occurred. So I think that that's just a completely different set of facts, and that is why a jury decided the way they did with regards to that. But I also think, that kind of supports our argument of clear error, and it shows that they might be tempted and they're reasonable enough to consider lesser included, and they didn't in Burton's case. So I don't believe giving him an involuntary manslaughter would have changed the result.
Okay, thank you.
Thank you. Without any further questions, I think I'll sit down.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Regarding the factually appropriate, State's counsel did say that self-defense is an intentional act, and voluntary manslaughter, imperfect self-defense encompasses self-defense. It says a lawful act, which this court has said is the act of self-defense. And so I don't know how you could unintentionally commit the act of self-defense. And so I think that it's in line with all the other, I guess, means of committing involuntary manslaughter may not be intentional. There's obviously reckless, and then DUI manslaughter, and I don't know what you would call it, but the felony murder that's not really with the felony. Those may be unintentional, but to commit the intentional act of self-defense, the lawful act of self-defense, requires intent. And so
How would you argue that then should be considered by the jury? The involuntary manslaughter that you're requesting, should it be considered typically in the sequences how we do it, or should it be simultaneous? And if it's simultaneous, why?
I believe that it should be considered simultaneously, and there's arguments out there at the same as voluntary manslaughter, because the imperfect self-defense is a mitigating factor. And so if you aren't even presented with the opportunity to consider the mitigating factors, you haven't, I mean, we consider self-defense, which is a mitigator, alongside the charge crime. And so these mitigating factors that lessen some of the intent requirements, that mitigate some of the intent requirements, or some of the other facts, should be considered at the same time. And if you just don't have the opportunity to even get to the mitigating factors, even though there may be some mitigating factors that the jury finds, I think that's improper. So I do think that anything with a mitigating factor, the voluntary manslaughter, imperfect self-defense, and the involuntary manslaughter, imperfect self-defense, should be considered alongside second-degree murder.
So in this case, basically everything would be considered simultaneously.
Yes. And I think that it could be different if he was charged with recklessness. That requires this, well, he didn't act intentionally. Okay, I'm going to go to reckless. Reckless involuntary manslaughter isn't a mitigating fact. It's a different level of intent. But these two, they're defenses that contain mitigating facts to the intent. And I think that's all I wanted to say.
Any more questions? Thank you, counsel. We appreciate the arguments of both counsel this morning. Court will take this matter under advisement. That concludes